be jumping to the second question with yourself, Nick. This viewer states that they need advice with a tenant that was not charged utilities, as the utilities were not received by the landlord from the metering company for a period of 12 months. The landlord sent all the utilities to the metering company last month to invoice the tenant, and the landlord are now expecting the landlord is now expecting the tenant to pay the amount close to 30,000 rand. It does go to further to say that our lease stipulates that it remains the responsibility of the owner to ensure that the tenants receive the utilities monthly. But then also the tenant signed a lease agreement, and it is clearly in the lease that the water and electricity is not included in the rent. The viewer does say that they do feel that both the parties were in the wrong, and we are now somewhere stuck in the middle as the agents. Please advise the tenant, as they feel that they are not going to pay the amount, as they do not receive the monthly utilities. Nick?
Okay, perfect. So obviously in this particular circumstance, we've got a lease agreement, and the lease agreement's really going to be pinnacle in this particular circumstance. Thankfully, the writer has provided us with a couple of details. So the first thing is, are the tenants liable for the utilities while they're staying on the premises? We've been told yes. The lease agreement states that they are going to be liable for the utilities. Okay. And the other thing that the lease agreement says is the landlord must provide the utilities to the tenant. So that's a very common clause within lease agreements. Basically, utilities are a bit different to rental, okay, or certain other charges in terms of a lease agreement, because they are charged generally in arrears. So you get to use the utility, and then whatever your usage is, that is provided to you, and you are expected to pay these amounts. Okay, this is very common. And so what lease agreements do is, instead of saying something like rental, which is payable in advance, utilities will be paid upon presentation. Okay, so usually this is the invoice that's rendered by the landlord to the tenant, saying this is how much utilities you used within a previous period. Okay, and when that is given to them in terms of an invoice, that is when this amount becomes payable. Now, what we've been told in this question is the landlord didn't have access to these the usages for a period of 12 months for whatever reason. Okay, there's a metering company that's a long time for a metering company to not be able to give you your readings, but we'll take the facts as they are. What the landlord is now doing is, after a 12-month period, he is now presenting the utilities to the tenant. And so, provided the lease agreement, as we've been told, says that you're going to pay it on presentation, that requirement has now been done in terms of the lease agreement. Okay. So, bar there is some very particular clause in the lease that says utilities must be presented by the landlord within a certain period. Okay. This is a perfectly acceptable way to present the utilities to the tenant. Okay. It is late, and it has accumulated quite an amount, but notwithstanding, the presentation has now occurred. Okay. There is nothing, unless there's a specific clause within the lease agreement, nothing allows the tenants to say, I'm now not going to pay because I think that 12 months is too long. The only exception to this particular rule would be perhaps prescription. So just to mention quickly on prescription, prescription is something within our law that says you cannot enforce a debt against another party within a certain time period. And between civil people, normal everyday people within the economy, that's generally a period of 3 years. So if you're trying to enforce a debt which is longer or older than 3 years, there is a question mark whether it is in fact enforceable. But in this particular circumstance, we're dealing with 12 months. So prescription is not even an issue that we can deal with. So bar something specifically in the lease that says you cannot enforce these utilities over a certain period, the tenant's absolutely going to be liable for these utilities. In fact, what is more common in lease agreements is clauses that protect the landlord in certain circumstances. So there are often clauses in lease agreements that say, conduct by the landlord will be without prejudice to their rights in the circumstances. So the fact that they've issued previous invoices which didn't have utilities on, because he didn't have the utilities at the time, is not going to prejudice his rights to claim utilities in the future. That's a very common clause that sits within lease agreements, and far more common than a clause that would say you can't enforce your rights within a certain period. In fact, the legality of such a clause to say you can't enforce your rights would be very, very questionable in circumstances. So I don't think the tenant is going to be able to refuse payment of these accounts in any particular way. That being said, we'd like to, there's a legal way of doing things, and then there's a practical way of engaging with one another in an economy and within an agreement. And you must understand the realities of situations. I know from Bruno's side and from my side, taking people to court and having these fights, really, when a practical solution can suffice, is a waste of time and money for clients. So if someone came into me, okay, and said, this is the circumstance, the recommendation is always, look, the debt is enforceable, but what you must understand is producing a bill of 30,000 Rand for a tenant to pay immediately is a difficult task for even the most wealthy within our economy. So there is a circumstance that happened. You didn't have rates for a long time, but as the landlord, I would also suggest that maybe you come to the table and help the tenant out in the circumstances, and don't expect all of that money to pay it up in one shot. The landlord might also be under pressure from the metering agency or whatever the case is. And I would say that the same advice to them. You guys haven't done your job for 12 months, so you should try work with everyone a little in the circumstances. So while that debt is payable, I think everyone does need to take a little bit of a seat and say, how can we resolve this matter as easy as possible, instead of hammering down the legal route. And that generally will mean that everyone walks away a little bit happier if payment can be made a bit slower, but landlord still gets payment at the end of the day.
Sure. No.
Yeah. Okay. Great. Yeah, absolutely. Thank you very much, there, Nick. Obviously, a nice suggestion of some sort of middle ground and mediation towards the end. Yeah. So we've covered the Brodie Corporate and Homeowner Association in relation with the SAPS and inspections, and we've done one question on the utilities and metering companies. And towards that does bring us to the end of today's question and answers. And thank you much, everybody, and we'll see you guys again next week.
Thanks
so much, guys.
Thank you.